Welcome to This Explainer. Okay, let's just jump right in. Today, we're tackling something that frankly makes most of us pretty uncomfortable to even think about, and that is medical mistakes. We hold our doctors, our nurses, and our entire healthcare system to this impossibly high standard. We basically expect perfection. But the reality, medicine is practiced by humans, and humans make errors. So in This Explainer, we're going to pull back the curtain and look closely at what actually happens when things go wrong. We'll be looking at medical error specifically in relation to professional competence, and we're going to break down the whole complex web of legal and professional ramifications that inevitably follow. 237 million. Let that number sink in for a second. That is the staggering estimated number of medication errors made every single year in England alone. When you hear a massive number like that, it instantly shatters the whole illusion of a flawless healthcare system, doesn't it? Errors aren't just some rare anomaly. In a system this incredibly complex, they are a statistical inevitability.
And look, those errors carry a massive weight. As the BMJ Quality and Safety Journal points out, the avoidable consequences of these errors cost the NHS upwards of £98 million and, far more tragically, over 1,700 lives every single year. So the stakes literally could not be higher. This just proves that perfection in healthcare is a total myth, which brings us to a really crucial question. If errors are inevitable, how do we actually hold the system accountable?
Well, here's our roadmap for today. We'll be covering 1. When medical errors happen. 2. The duty of candor. 3. Handling patient complaints. 4. Professional competence and the GMC. 5. Civil law and negligence. And finally, 6. The standard of care.
All right, Section 1. When medical errors happen.
Before we get into all the heavy accountability stuff, we kind of need to build a little empathy and understand the context. Doctors absolutely do not go to work wanting to make mistakes. Errors happen for a whole variety of very human and very systemic reasons. Maybe it's grueling fatigue, a temporary distraction, a lack of senior supervision, simple bad luck, or just widespread systemic issues like short staffing. When these things lead to a mistake, it's classified as a medical error. And understanding this reality is vital before we start looking at the strict regulations that govern professional competence.
Moving on to Section 2, the duty of candor.
So what happens immediately after a mistake? Healthcare providers must practice candor. The precise definition of this, which by the way gained massive prominence after the 2013 staff retire inquiry, is super fascinating. Candor isn't just about answering questions honestly if a patient happens to ask. No, it is the proactive volunteering of all relevant information to anyone harmed by the service, regardless of whether a complaint was made or the information was requested. Basically, you cannot wait to be found out. You have to step forward.
Now, for an individual doctor, this professional obligation is tightly defined by the General Medical Council, or GMC, right there in their Good Medical Practice Guidelines. If a patient under a doctor's care suffers harm, the doctor is required to do 3 specific things: put matters right if it's clinically possible, offer a genuine apology, and fully and promptly explain exactly what happened and the likely short and long-term effects. Hiding the error? That is a massive, career-threatening breach of professional competence.
But here's the kicker. Candor isn't just on the individual doctor. In places like England, healthcare organizations themselves hold a statutory, legally binding duty of candor. They're regulated by bodies like the Care Quality Commission, the CQC. So if a hospital tries to sweep a serious patient safety incident under the rug, the CQC can actually step in and prosecute the organization for breaching that duty.
Section 3. Handling patient complaints. This quote from the 2013 Francis Inquiry brilliantly illustrates why patient complaints are not just some annoying administrative burden. They are a vital early warning system. A system that doesn't listen to complaints basically allows unacceptable practices to just persist. Complaints dig into the what, why, and how of an error so the hospital can actually figure out how to stop it from happening again.
The official NHS feedback and complaints procedure usually kicks off with local resolution. That means raising the issue directly with the hospital or GP practice to see if it can be sorted out right there. But if it's not resolved to the patient's satisfaction locally, the whole thing escalates. It can actually go all the way up to the Parliamentary and Health Service Ombudsman for a completely independent investigation.
All right, Section 4, professional competence and the GMC.
So the GMC gets hit with a massive volume of complaints. We're talking anywhere from 5,000 to 9,000 a year.
But look, their job isn't to punish every single little mistake. Their job is to screen these complaints to determine if a doctor's overall fitness to practice is impaired. And while thousands of cases are closed right at the initial triage stage, a study portion do advance to full-blown investigations or hearings.
What actually triggers one of these full GMC investigations into someone's professional competence? It usually falls into a few main buckets: misconduct, deficient performance, a criminal conviction, or even adverse health. Let's think about a hypothetical. Say Dr. A realizes they have a drug addiction and proactively self-reports to the GMC. Because they're actively seeking help, they might just face restricted practice while they recover. But contrast that with Dr. B, who deliberately alters patient notes after a complaint is made just to cover their tracks. That is severe misconduct. It's a massive probity issue, and the GMC treats that incredibly harshly.
If a case actually goes to the Medical Practice Tribunal Service and they find the doctor's fitness to practice really is impaired, they have this ladder of escalating sanctions. 1. They could take no action. 2. Ask the doctor to accept certain undertakings. 3. Place strict conditions on how they work. 4. Suspend their registration temporarily. And 5. In the absolutely most severe cases of professional failure, like our friend Dr. B altering those notes, they can erase the doctor's name from the medical register entirely. Game over for their career.
Section 5. Civil law and negligence.
Okay, we really need to clearly separate the two domains of law here. Criminal law actions like charging a doctor with gross negligence manslaughter are exceptionally rare. The bar for criminality is incredibly high. What's much more common is civil law. This is where a patient sues for financial damages, typically using what's called the tort of negligence against the NHS or private provider.
But, you can't just sue because you had a bad outcome. You have to actually prove negligence on the balance of probabilities. To win a civil suit, a plaintiff must prove 3 mandatory things, in order. Step 1. The doctor had a duty of care to the patient. Step 2. The doctor breached that duty of care. And Step 3. That specific breach actually caused the harm. Let's break those down.
Now, Step 1, establishing that duty of care, is usually pretty easy. If you're a patient in a hospital, your doctor owes you a duty of care, and the NHS Trust carries what's called vicarious liability for their staff. Simple enough, right? But here is a wildly fascinating legal quirk. In the UK, there is actually no Good Samaritan law. Legally speaking, a doctor walking down the street has absolutely no legal obligation to stop and help someone having a heart attack. However, GMC ethical rules state they should help if it's safe. But be warned, the very second that doctor steps in to help, a legal duty of care is instantly established.
Finally, Section 6, the standard of care. How does a judge actually decide if a doctor messed up? Well, they use 2 famous legal precedents. First is the Bolam test from 1957. It basically says a doctor isn't negligent if they acted in accordance with a practice accepted as proper by a responsible body of other medical professionals. Basically, if a group of your peers says, yeah, we would have done that too, you're protected. But fast forward to 1996, and the Bolitho test added a major caveat. That pure approved practice must also have a logical basis. So ultimately, the court has the final say, not just the doctors.
Which brings us to a really compelling question about professional ramifications. Are junior doctors held to the exact same legal standard as senior consultants? Let's look at a hypothetical scenario. Meet Dr. Osman. He's a brand new FY1 junior doctor on a crazy busy night shift. He's told by a very intimidating senior registrar to draw arterial blood from a deeply anxious, needle-phobic patient. Osman doesn't really know what to do, the patient is getting hysterical, and his senior has explicitly ordered him not to bother him unless someone is actively dying. The pressure is immense. If Osman proceeds in a total panic, messes up, and the patient is harmed, who is legally accountable?
The legal answer? It's a bit of a harsh reality check. In court, lack of expertise is taken into account. You are judged by the standard of your specific role. A GP is not judged by the standards of a brain surgeon. However, lack of experience within your role is not taken into account. The law absolutely does not lower the standard of safe care just because Osman is a beginner. It might seem harsh, but it's designed to protect patients. The ultimate takeaway for professional competence is this: junior doctors must never go it alone. If you aren't competent to proceed, the law demands you seek senior advice. Navigating medical error is all about balancing the fact that humans make mistakes with the absolute legal requirement to maintain patient safety above all else. Which leaves us with one final, very difficult question to ponder. If perfection is truly impossible, but the legal standard remains uncompromising, How do we best protect both the patient on the table and the human being in the scrubs?